There's been a lot of emphasis in the last 18 months on remote hearings in arbitration and litigation because of the COVID pandemic. But the question is, are they a compromise or are they here to stay? I'm here with Robert Hunter and Alex Kirschstein, partners in Osborne Clarke's dispute and risk practice, and we're going to talk about their experience of remote hearings over the last year. So Robert, do you think remote hearings work?
Most definitely, yes. We've had quite a few days of experience of them now, 15 at least in arbitration and quite a few in litigation too. They work, in my experience, really well in both important respects. The first is effectiveness. Definitely cross-examination in particular works really well in a webcam-based remote hearing. I would say even better than in a courtroom. And they've also proved to be very efficient in terms both of scheduling and cost.
What do you think, Alex?
Well, we know they work. We now do. I think what didn't work was not the hearings. It was the way to the hearing. There were fierce discussions, negotiations about whether to have a remote hearing or not. Then, of course, about the protocol, all kinds of things. It was an extremely cumbersome process. And my advice to any business, anybody who does arbitration, has agreed to arbitration for their means of dispute resolution, should spend thought on amending their terms of business, maybe their arbitration clauses, to say something about whether or not to have hearings, to, as you generally do in your terms of business, you state what you want and what you don't want. But you should definitely do that, because if you don't, you'll find yourself in situations where you have your lawyers spend a lot of time on negotiating things that could easily be pre-agreed.
Why do you think there's been such a reluctance surrounding the use of remote hearings?
I'm pretty sure the main reason has been simply a fear of the unknown. All my professional career, which is over 30 years, I've had face-to-face hearings with occasional single witnesses by video conference, and my experience of that had been unsatisfactory. My experience of remote hearings where everyone has been before web cameras has been universally positive. And I expect that the more people who experience virtual hearings, remote hearings, the more commonly they will be accepted. But in the transitional time, my fear is that they will be very hard to agree out of a lockdown situation with counsel, with businesses who've not yet experienced them.
Yeah, that's true. I think the remote hearings started out as a compromise, but now they're here to stay. And I can hardly think of a reason why you would not agree to a remote hearing. They're efficient. They're especially cost efficient. They're environmentally friendly. And I think these are the two drivers of business in general. So why would you not agree to a remote hearing? In practice, we had several, and they're not in a single case. There was a technical problem, an ethical problem, a problem, the right to be heard in court, anything like that. They're generally unproblematic.
Are there any specific conditions that you find work for remote hearings?
There's one absolute necessity, which is that the witness is siloed in a Zoom or Teams webcam situation. One of the biggest lessons I learned is that there is a difference between what we thought of traditionally as a video conference and the new wave of siloed webcam hearings. And it's definitely the second, which in my view is an absolute precondition of a remote hearing. You have to have a witness in full frame.
And what do you mean exactly by siloed?
Each participant alone in front of a webcam. In the two hearings I've had so far, We also, as counsel, have done that. And in both cases, opposing counsel has been in a video conference situation. That is not, in my view, a precondition doing one or the other. It's a precondition for the witnesses. But in my experience, we were actually in a better position also as a legal team being siloed individually before webcams.
And technology-wise, what do you think is the most important equipment to have to make the remote hearing work effectively?
Well, number one, of course, is a strong and reliable internet connection for every participant. Number two is a decent quality camera and audio.
But there must have been challenges as well in the remote hearings.
With adequate preparation, my experience is that technical hitches are rare. In the 10 full days of witness examination I've had, we had only one brief interruption. So the two necessities there in terms of preparation, first of all, have a reliable internet connection, make it a duty of each party in the tribunal to make sure it works, have a dress rehearsal. And the second is, in all cases, we've had a written protocol to agree what happens in the case of an interruption.
How do you come up with the protocol? What should go into it?
The first time we did one, I looked around on the internet and I took various precedents. Some of the arbitration institutions have them. There were also quite a lot of seminars and YouTube videos. I watched all of those and came up with our own product. As the lockdown has progressed over more than a year now, there's a great deal around, and some tribunals have their own, council have their own. But they were a lot of trouble to put together and to negotiate the first time round.
Yeah, I had the same experience, the trouble negotiating this protocol. In the end, we didn't need it at all. Of course, one of the concerns is technology, that if technology works for the remote hearing, we didn't have any problem whatsoever.
In that case, what would you recommend?
My simple recommendation is that you must write down what you want now. The issue of remote hearings is not going to go away. It's come of age during lockdown. And in every case now, there is going to be a question asked, do we have a face-to-face or a remote hearing? My personal recommendation, based on my experience, is that in almost every case, you should prefer a remote hearing. There may be exceptional cases where that won't work. But whether you want one or not, do say in your arbitration agreement, in your transactional agreement, which you want. Because if you don't, first, you're going to spend time arguing about it, which is inefficient and you can avoid. And secondly, you may end up with the solution you don't want. So decide what you want and write it in.